whatever. Okay, my lovelies, I know you've been so excited to learn about these three branches, and today is the day that we finally conclude with our third branch. We've talked about the legislative branch, we've talked about the executive branch, and now it's all about the judicial branch. So we're going to talk a little bit about some basics about the court, and then we'll talk a little bit about our 9 Supreme Court justices, so that when you are giving your presentations about historical court cases, you'll have a little more context for it. Are you as excited as I am? I hope so. Okay, let's start off and talk a little bit about some basics and terms. So first of all, what is the purpose of the court system? Why do we have this whole thing? Well, the main purpose is, of course, to resolve legal disputes. So we're resolving legal disputes, and this can be in 2 different categories: criminal or civil cases. When we're talking about criminal cases, we're saying it's the people versus an individual. And the people is often used in quotation marks, because when it's the people versus an individual for a criminal case, that often means that the people is representing a government. So people could be representing California, the people could be representing San Mateo, the people could be representing the United States government. And versus an individual. I'll talk a little bit more about what that means in a moment. In civil cases, it's going to be an individual versus another individual. So in civil cases, we're thinking individual v. another individual. And in this context, we're thinking individual often represents and means an actual person. However, individuals can also be businesses or corporations or even another government agency. So think about the criminal when it's the people versus an individual. That can be an actual person, or it could be an actual business. So when there was that scandal about Pharma Bro, Martin Shkreli, that's when we had the people, which at this point was the government, versus Shkreli. He represented himself, or against him. Also, it could be against the actual pharmaceutical company. So individuals can represent both people and companies. And we'll hear about that even more when we learn about Citizens v. United. Anyhow, let's talk a little bit more about litigants and plaintiffs and defendants. So a litigant is a person or people that are engaged in a lawsuit. So if you are engaged in a lawsuit, you are a litigant. And it actually comes from the, whatever it's called, that old dead language that everyone used to learn about that I'm totally blanking on, but at some point it'll come back to me. So litigants are people engaged in lawsuits. A plaintiff is the person who brings the suit. So they're the ones who bring the charge, they bring the suit. In this lovely little drawing we have here, the lady who's saying, "He stole my wallet," she's the plaintiff because she is bringing the suit. And a defendant is a person against whom the suit is brought. So the person against whom the charge is brought against. So a person being charged with the crime, they have to defend themselves. So it's the person against whom the suit or lawsuit is brought. Now, a judge will hear from the defendant, they will hear from the plaintiff, and then they will offer an indictment sometimes. An indictment is a formal charge by a grand jury. So an indictment is a formal charge. And we actually hear about this with our first and Articles 1 and 2 with our legislative and executive branches, because oftentimes we can see indictments, these formal charges, being brought against the president. They've been indicted, as well as members of Congress. So that formal charge by a grand jury. Now, when we're talking about a precedent, and this is a term that you might have heard in other contexts, but a precedent is a ruling that sets guidelines for future similar cases. So it's a ruling that sets a guideline for a future similar case, which means that if the Supreme Court or a court reviews a case and they make a ruling, they say blah, blah, blah equals X, and then in the future, you get a similar lawsuit that's brought up, the judge will refer back to that and say, well, according to precedent, according to this previous law case, we're going to judge based on X or Y or whatnot. Now, if you do not like how the judge has ruled, they've ruled not in your favor due to precedent or other reasons. That odd noise you're hearing might be my dog chewing her very loud bone. Thank you, Effie. So if you don't like how the judge has ruled against you, you can offer an appeal. And this is another term that we've heard in other contexts. When you appeal for something, when you appeal in the judicial sense, you are applying to a higher court for a reversal of the decision from that lower court. So in this context, you are applying and you're actually going to go to another court level. So you're not going to go to the same court level, and I'll talk about court levels in the next few slides. So you apply to a higher court for a reversal of the decision from the lower court. So you say, I don't like how this lower court ruled. I'm going to go to a higher court and ask for them to reverse the decision, because only they would have the authority. This is how court cases often end up at the Supreme Court, because it starts off at the lower courts, people don't like it, they appeal, and then they go off to the Supreme Court, who then rules officially. And of course, we can't talk about anything judicial without talking, of course, about due process. It's an oldie but a goodie from good old Amendment number 5. We also see it come up in Amendment 14. And due process: no state may deprive any person of their right to life, liberty, and property without due process of the law. That basically means that you have to go through the process to charge someone with a crime. You can't just wake up and say, you know what, I don't like so-and-so, so I declare that they are a murderer, and then they have to go to jail. Instead, you have to go through the process. You have to formally charge them with a crime. They get to defend themselves. It goes through the courts, etc., etc. So nobody's being deprived of their life, liberty, and property without due process of the law, following the procedures of the law. Oh, Effie found her bone again. Awesome. All right, let's talk a little bit more about another very important concept, and this is jurisdiction. You've often probably actually heard me talk about this in class sometimes, but legally, we're talking about jurisdiction, and it's the authority to hear cases. And we're going to see this authority in many different levels. So first of all, there's can be a dual system of state and federal courts. So there's state jurisdiction, and then there is federal jurisdiction. And the dual system means that you see that there are state and federal courts happening at the same time. State courts hear cases involving state laws. That makes sense. So California state courts, they are going to hear cases involving California laws. We're not going to see them hear cases from Nevada or Oregon or other states, nor are we going to hear California review federal laws. Instead, state courts are going to hear cases involving state laws. Now, where will federal laws be heard? In the federal courts, of course. These are federal courts will hear cases that involve U.S. laws, as well as treaties with foreign nations, and anything that is dealing with interpreting the Constitution. So when we're talking about the federal courts, they look at U.S. laws, they look at treaties with foreign nations, and interpretations of the Constitution. They also review ambassadors. If there's any issues coming up with ambassadors, it goes to the federal courts. Any issues that involve 2 or more state governments. So if California sues Nevada because of something about Lake Tahoe, which is shared between the 2 states, it would be reviewed in a federal court, which makes sense because you can't have Nevada and California's conflict reviewed in California court or Nevada court because they would have a bias, as well as citizens from different states. So if you're citizens and you're having issues and you hail from different states, it's going to go to a federal court as opposed to having bias in your own personal home court. All right, a little bit more. We also see this concept of concurrent jurisdiction, and this is when both state and federal courts have jurisdiction. And you're thinking to yourself, but Ms. Dub, you just said state courts are state laws and federal courts are federal laws. How can they have concurrent jurisdiction when both state and federal courts have jurisdiction? This doesn't happen too frequently, but typically if you're having issues from citizens that are coming from different states, and the issue is concerning typically more than $75,000, so something of a large scale, then we'll see concurrent jurisdiction come into play. We also have the concept of original jurisdiction, and this is when jurisdiction lies with the federal district courts, which we'll talk a little bit more momentarily. And then finally, we also have appellate jurisdiction, and this is jurisdiction that deals with the Federal Court of Appeals. So big thing to know about this is original jurisdiction, we're talking about the district courts, appellate jurisdiction, the Federal Court of Appeals. Let's talk a little bit more about the structure and some of these courts that I've just been referencing. So the structure of our judicial court system is a tri-level structure, 3 levels. We have our federal district courts at the base level. We have the Federal Court of Appeals at the middle level, and then it's topped off by good old Supreme Court. So federal district courts, the only thing we really need to know, because we could spend an entire rest of the semester, if not years, talking about federal district courts, but for our intents and purposes, we need to know that there are 94 of them. It's based off population. So there are 94 district courts all over the United States. And these are your basic trial courts. So these are going to be dealing with all the cases that come to trial, dealing with U.S. laws as illustrated from the previous slide. Now, if you do not like how the court case, how the ruling was brought about, if you disagree, you would then appeal that decision. It's going to go to the higher court. And in this instance, the higher court is your Federal Court of Appeals. Your Federal Court of Appeals is in 12 judicial circuits that you can see on the map there below. So you can see a whole bunch of districts that are kind of crammed over on the East Coast. And then we have District 9 that covers us and the rest of the West Coast, as well as Alaska and Hawaii. Deals with population. When the district courts were created in the early 20th century, not as much population. Now, we'd probably see a slightly different layout, but what are you going to do? So we see that there are these 12 judicial circuits, which means that there's one appellate court in each district. So for each judicial circuit, judicial region, they have one appellate court. There is a 13th court, and it's kind of a floater. It has national jurisdiction, and it can go and kind of go where it's needed. My guess would probably be it ends up more in the West, just because there's a lot more people out there than that 9th district court could really handle. Who sits on this district court is a panel of 3 judges. So oftentimes when we think about judges, we think that there's just one, and that's the case for the district court. But the Court of Appeals, it's a panel of 3 judges that sit on this court. It's a pretty important deal. We've heard about them a lot. So when the Muslim ban happened last year, when Trump issued a ban on individuals coming from countries primarily where there's a large Muslim population in the Middle East, he was immediately sued by the people, and it actually went to the 9th District Court, who then ruled that that was a violation of constitutional rights. So the 3 judges, they got to rule on it. And, it's even odd. So if 2 judges vote yes. Oh, no, I lied. I think they all have to be in agreement. Anyway. All right. And then finally, at the top level, we have the Supreme Court. Supreme Court has the final say in all matters dealing with the Constitution. If you are appealing your case at the district court, it goes through the appellate court and you still don't like it, then it's going to go up to the Supreme Court, assuming that they hear it. But basically, what do we need to know? The Supreme Court has the final say in all matters dealing with the Constitution. Let's talk a little bit more about the Supreme Court, shall we? All right, here's some basics about it. So as I said, basics of the Supreme Court, it is the highest court in the land. There's nothing higher, just like the the Constitution is the supreme law in the land. The Supreme Court is the highest court in the land. I don't know, our founding fathers are really feeling supreme. Latin, that was the dead language that I had forgotten about, that all this is coming from. It's come to me now. How exciting. All right, back to the Supreme Court, the highest court in the land. There are 9 justices that sit on the bench. You can kind of see it in that bottom picture there. That's an actual picture of the inside of the Supreme Court. Pretty exciting stuff. So those 9 justices, they sit on the bench. You have 8 associate justices and 1 chief justice. So of the 9, you have 8 associates plus 1 chief justice. It equals 9. Go math. What do these justices need typically? They typically need to have a lot of legal experience. So they are typically justices that sit on lower courts. So you're never going to get someone that's just a lawyer and suddenly is hired for the Supreme Court. That's not going to happen. Typically, they have legal experience, so they sit on the District Court of Appeals. They just sit on a district court. You have had Supreme Court justices that have had legal experience in that they've served as members of Congress or even presidents in the case of President Taft. But most often they are sitting on lower courts. These court justices also typically have upper socioeconomic backgrounds, that they come from wealthier backgrounds, and we'll see that when we look actually at our Supreme Court justices. And the Chief Justice, he, and I'm saying he because we've never had a female, although we've had 4 women that have served on the Supreme Court bench, 3 of which who are currently serving, so good job diversity. So Chief Justice, he provides leadership. He's kind of seen as the leader of it. And often is kind of the spokesperson. When presidents are inaugurated, it's the Chief Justice who gets to, have them sign or say the oath, gets to be kind of the face person of that. All right, Chief Justices, we know, or I'm sorry, all justices, thinking about our checks and balances, they are going to be appointed by the president. And usually they are going to be aligned politically. So that means that because you have the presidents that are appointing them, typically Republican presidents are going to nominate or appoint Republican judges, and Democratic presidents are going to be appointing Democratic justices. Now we know that Supreme Court justices, they serve for life. So this is a way in which presidents can really extend their influence over the government, because what ends up happening is they will nominate or appoint a president or appoint a justice who will then serve for decades after they leave, which is kind of crazy and intense to think about. And it's a very, very important power. And once again, why it's so important for you all to vote, because your vote matters and you all have to vote. Also, when we're thinking about who's appointing these justices, we also see that interest groups, who we just talked about last week, are also playing a role because they often attempt to influence the selections. So interest groups are always going to attempt to influence the selections because they want a justice who is going to be aligned with their values, who's going to promote their goals, and not rule against them. And then finally, as I mentioned, those checks and balances, if it's appointed by the president, the executive branch, it must be approved by the legislative branch. So it must be approved by Congress, by the Senate. So justices are appointed by the president and approved by Congress. Congress has some additional checks and balances over the Supreme Court in that they get to set the salaries, and they can also remove them. We have not seen too many judges being removed from office, especially in the 20th century, although in the 19th century, it did happen from time to time, most often for drunkenness and disorderly conduct. But fortunately, our Supreme Court judges have kept it a little classier in the 20th and 21st century. But always something to look out for, I suppose. All right, a little bit more about the Supreme Court, some more about their basics or about their duties, what they're responsible for, as well as the term. These responsibilities have evolved from tradition. So the Supreme Court, we've had it since the 18th century, and the judges largely do similar to what they did back then because it's built on tradition. If you remember looking at our Constitution, we saw a lot in Article 1, we saw quite a bit in Article 2, and there's not so much in Article 3 because it's really their rules have evolved a lot more from tradition. All right, what is the main duty of the Supreme Court, of these 9 individuals? Their main duty is to hear and rule on cases. So that's pretty much all they do. Unlike Congress and the president, who oversees foreign and national and agriculture and business, really the Supreme Court, all they do is hear and rule on cases. They get to decide which cases they will hear. So they get to decide that. They decide which cases they will hear. However, they cannot initiate cases. So if Sonia Sotomayor is like, hey, I really think we need to look at how teachers are not being paid enough, she cannot initiate that. Instead, they have to wait for litigants to bring the cases to them. So they cannot initiate cases, but instead must wait for litigants. What else do? They make decisions. And they share those decisions. They share the explanations for the decisions. So they hear the court cases and then they decide on it. They rule in favor of either plaintiff A or defendant B, or they rule in favor of the government, or they rule in favor of the person bringing the suit. And then they share that. And they share this through what's called an opinion. An opinion is a written statement on cases that have been decided. So they make decisions and they share it. They share it through an opinion, which are written statements on cases that have been decided. The term for the Supreme Court begins on the first Monday in October and ends typically in June, unless things are getting real crazy. For example, in 2008, it began, or 2007, it began in October, and the term did not actually end until right up until the end of September the following year. But typically it goes from October to June, and then they get a little bit of a break to go write some books and have speaking appearances and just be cool elderly people, I guess. The justices are going to sit for 2 weeks each month. So they'll usually sit for the first 2 weeks or the second 2 weeks of the month. And that's where they will listen to oral arguments about cases that have been brought to them and then retire to decide on their opinions. So they listen to oral arguments about the cases and then retire to decide on their opinions. Opinions can be in two ways. You have the majority opinion, and then you also have the dissenting opinion. So majority opinion is obviously with, the majority of justices, so 5 or 6 or 7 or 8 or 9. And then the dissenting opinion is the minority, the ones who did not win, so that's going to be your 4 or less. Also, just interesting, thinking yourself, wondering, how many court cases do they actually hear? They typically hear somewhere around 80 to maybe less than 100, but usually around 80-ish or so, despite the fact that literally thousands, if not tens of thousands of court cases are brought to them. So lots of court cases are brought up to them, but they only decide to hear about 80-ish or so. All right, let's meet these individuals in a little bit more greater detail. So we're going to start off with our Chief Justice, and he's a man named John Roberts. Like I said, he was appointed as the chief. He replaced William Rehnquist, who retired. And he was appointed by George W. Bush in 2005. So this is one way in which we see George W. Bush's legacy continue on. He was appointed in 2005. John Roberts was a graduate of Harvard and Harvard Law. You don't need to write that down, but you're going to see some similarities here. And he was born in 1955, so he still is relatively young. Another thing to note is that he's pretty conservative, although recently he's come out a couple times as swing vote. He's actually aligned with the more liberal judges on the bench, which is a little surprising and unexpected. But important for us to know that he's appointed by George W. Bush in 2005. Moving on. We have Clarence Thomas. He's Associate Justice. He was appointed by George W. Bush's father, George Herbert Walker Bush, in 1991. So a long time ago. And in fact, he is our oldest serving or longest serving judge. And there's some people feel like he might be retiring soon, but I don't know. But regardless, he's been on the bench for nearly 30 years. So George Herbert Walker Bush, who has passed away recently last year, we still see his legacy continue. Clarence Thomas is actually, despite the fact that he was appointed like 25 years prior to John Roberts, he's actually only 7 years older than him. He was born in 1948. He's a baby boomer. He's super conservative, and he went to Holy Cross and Yale Law. You can see Yale a whole lot. Our next longest serving justice and one of our oldest justices is Ruth Bader Ginsburg, the notorious RBG. She was appointed by Bill Clinton in 1993. So again, now we see Clinton's legacy continuing from 1993. She went to Cornell and Columbia Law, although she actually started at Harvard Law. And then her husband got into Columbia, and she then had to leave after her first year and transfer. One of the first women to do so, because at that time, of course, the man's not going to transfer for the wife. The wife is going to transfer for the husband. So interesting facts about her. She was born in 1933, so she is seen some things, seen some years, and she is our most liberal member of the bench. The next justice, the one that I always forget about, is Stephen Breyer. He was appointed in 1994, so he's been around for a while. Also appointed by Bill Clinton, despite the fact that he was conservative. Kind of interesting. And that goes back to those checks and balances, because when Bill Clinton appointed Breyer, he did not have a Democratic House and Senate, so he had to appeal to the Republican-controlled Senate, which is how you end up with a more conservative judge on the bench from a Democratic president. He's a little bit younger than RBG. He was born in 1938. He went to Stanford and then moved on to Harvard. So, got some West Coast representation of elderly man. Good job, Supreme Court Justice Stephen Breyer. All right, moving on to Alito. Samuel Alito, he's also very conservative. He and Clarence Thomas used to kind of jockey for second most conservative behind the dearly departed Antonin Scalia. Now, I'd probably argue that Thomas is more conservative than Alito, but what are you going to do? Alito, he was appointed by George W. Bush in 2006. And he's a graduate of Princeton and Yale Law, born in 1950. Effie, stop that. And like I said, very conservative. Effie, stop that. Effie's getting into some things. All right, jump forward ahead to the 21st century with some appointments. We have Sonia Sotomayor. She was appointed by Barack Obama in 2009. She went to Princeton and Yale Law. She's a bit younger than her compatriots here. She was born in 1954, and she is pretty liberal. So she's also the first Latina that we've had serving on the bench. She was known, in fact, during her appointment hearings, everyone called her the wise Latina woman, which was just a weird thing, but all right. Barack Obama's next appointed appointment, which now it looks like I just wrote appointed liberal, but you know better than that. And you know that you're going to write appointed by Barack Obama in 2010. Also went to Princeton and Harvard Law. She is liberal. She's one of our youngest serving members, born in 1960. Super young, born in 1960. All right, and then we have our final two members of the bench. We have Neil Gorsuch, who was appointed by Donald Trump in 2017. Neil Gorsuch actually replaced the empty seat of Antonin Scalia, who passed away unexpectedly in 2016. Barack Obama brought forth many appointments, or thought about bringing forth many appointments. He actually appointed a man named Merrick Garland, but the Senate, who was controlled by the Senate Majority Leader, continued to be Mitch McConnell, basically blocked that appointment. So we see some checks and balances until the 2016 election happened, and then Donald Trump was able to bring forth Neil Gorsuch. So when you think about the importance of voting and why it's so important for you to vote, had Hillary Clinton won, although ironically she did win the popular vote, so had our Electoral College worked off popular vote, or had a couple key states gone for Hillary Clinton, then we would not have seen Neil Gorsuch on the bench, and instead we would have seen a liberal member of the bench. So once again, how important it is to vote, and also how these presidents continue to have their power kind of extended beyond their presidency. Neil Gorsuch, he is, I believe, the youngest member of the bench, born in 1967. So super young guy, born in 1967. As I've said, he's conservative, appointed by Donald Trump in 2017, and he went to Columbia and Harvard Law. So we're hearing kind of the same Ivy Leagues over and over again. That's where you kind of get that coming from upper socioeconomic backgrounds. And then the final, most recent member of the bench is Brett Kavanaugh. We heard a lot about him in the news with the allegations of sexual misconduct from Dr. Christine Blasey Ford, as well as others. Despite all that, his appointment went through and was approved by the Congress in 2018, and he was appointed by Donald Trump, who was our president once again. He went to both Yale and Yale Law, a little bit older than Neil Gorsuch, born in 1965, and he is pretty conservative. So there you have it. Those are our 9 Supreme Court justices. Going back all in all, we have a little bit of diversity, pretty exciting stuff. And you can see that their powers are incredibly important because they serve for life. They will have rulings, will have repercussions for our government and our country for years and decades to come. So I hope that this has helped you understand a little bit more about the Supreme Court and the Judicial Branch. I look forward to hearing your presentations all about important court cases in the past. And I hope that you enjoy learning more about them and start thinking about how these 3 branches work together as we start to evaluate the effectiveness of our government. All right, my children, that is all. Enjoy, and I will see you all in class. Have a great night, morning, etc. See you soon. Bye.